Okay, so we're going to cover over exactly what is requirement by law in the UK of what a binding contract is. In the UK, verbal agreements are considered legally binding if they meet certain requirements. However, without written documentation, proven existence of terms of the agreement can be more challenging. The reason why it's harder to prove for the, let's say, verbal agreement, unless you've actually got it recorded, it's much more difficult to show what the offer exactly was and what the person agreed to. Requirements for a legally binding contract. Offer and acceptance. One party must have made a clear offer and other must have accepted it. This part is simply the person that is making the offer of a contract has to show exactly what they want the other person to do, and then the other person accepts it. As we said before as well, like on the other video, is if you make me an offer, for example, that entire contract is 10 pages long and you only give me 5 of the pages, even if I sign it, I've not seen all the documentation because you have not shown me. You cannot expect me to uphold my part of the agreement on the contract when you have not shown me the entirety of the contract. Intention to create a legal relation. Both parties must have intended to create a legally binding agreement, just like above. One person has an offer, one person has an acceptance of that offer. Both parties agree to follow the letter of the contract as such. In the contract, let's say for example, you say you will pay X person $10 or $10 for a specific item. I say I agree, so then I sign it. I have to sell you that item for that $10. When a written agreement is required, in the UK, law requires written agreements, for example, property transaction. Buying, selling or leasing land typically requires a written agreement. Credit agreements. Consumer credit agreements need to be in writing, because you can take on personal debt to purchase, say, goods. Credit agreements, consumer credit agreements need to be in writing. Guarantees. Agreements to guarantee another's debt also usually need to be in writing. Now, for example, with the city council or with the Scotting, realistically, if they have an expectation for you to pay the debt, just like when they have a expectation for you to pay rent, we agree to the tenancy agreement so we can actually pay the rent. So the other part is, if they have an expectation for us to pay the council tax debt from a third party person as such, and we have agreements set up to pay for it, or if we have an agreement, let's say, to set up to pay a debt with, the city council, this should be in writing. Therefore, they have proof that I agreed to pay such debt, and then I agreed to pay debt 2 with the funds I was paying for debt 1. That would have been in the agreement, which it was not. And if it would have been, since the 7th of last year, they would have sent me documentation stating I agreed to pay this debt for, let's say, debt 2 or debt 3 or any other debts that occurred with debt 1's agreement. So for example, could have put in the contract, Mr. X agrees to pay for, let's say, £200 of council tax debt. If Mr. X makes any overpayments, Mr. X is then obliged to use the overpayment of funds to pay for any extra debt he has. This would have allowed them to do what they have actually done. But like I have already stated several times, they made no such contract. If they did, they would have already contacted me, shown me the contract, stipulating I was obliged to pay because of this contract. If I had agreed to a contract like that, they would have sent me documentation within any of these emails that they have sent me since the 7th of last year, confirming I agreed to pay debt 2 or debt 3 with the overpayments occurred for debt 1. But they have not sent such letter. They have not sent any such email, which means I have not agreed for them to use my funds for debt 1, should I say the overpayments of funds for debt 1 to pay for debt 2 or debt 3. It's just proven that it is a breach of contract and they have committed misappropriation of funds and theft. And with one of the earlier videos I posted, we can also see by them taking those funds, sending it to Scott & Co, knowing the funds have already been paid for, then paying Scott & Co again, and then refunding themselves back the money, have committed microtransaction fraud, made micro payments to Scott & Co, potentially to try and hide the fact that they have taken funds illegally. There is a case for micro-online money laundering from them sending money to Scott & Co and then refunding themselves back the money, knowing that I had already paid off all the debts, and then paying Scott & Co again to delete the funds. They have lied to 2 local councillors, they have lied to an MSP, they have lied to an MP, I'm sure lying to elected officials in Aberdeen City Council's official capacity is something serious in itself. These elected officials have seen all the documentation, seen all the bills, seen all the microtransactions, seen the contradiction statements of the City Council worker when they caused assault and breach of the Human Rights Act. Now these elected officials are accessory after the fact The only thing they have done is gotten consent forms and then tried to infer that the matter has been settled. They have continued to allow City Council and the City Council employee away with theft, fraud, embezzlement, assault and breach of the Human Rights Act. Proven verbal agreement. This one is the annoying one because I originally got the agreement through verbally rather than just the email. The two local councillors, an MSP and an MP, has put in a consent form to get the information, and yet they have still lied to those councillors and those MPs and that MP, stating they offered me no such refund. Yet there was an offer made through a phone call, but they have hidden evidence to two local councillors, an MSP and an MP, hidden the fact that they've gave me a verbal contract. Of course, we've also shown the fact that they gave me written contract stating I could cancel the standing order to receive my funds, and they also stated to local councillors, that MSP and that MP, that they offered no such thing. And then later, on the latest email I received from Aberdeen City Council, also showed that I did not cancel that standing order. The reason why I never cancelled the standing order, because I was under duress, because I was threatened there could be consequences. Scott and Co were involved to retrieve funds to pay for that council tax debt. Said it was a court order, therefore inferring I would be in trouble legally if I would cancel that standing order. It's like when a police officer tries to force you to comply when they have no legal right to do so, then threaten to, convict you or threaten to do this to you. Especially, for example, the most common one is, if you don't speak to us, it could be bad for you in court as such. Whereas legally you have the right to stay silent, wait for your lawyer, and then speak to them. Not as if you want to, or then take it to court. They imply it's going to end up really bad for you if you do not say anything. It's true. It is also true. It's bad for you if you say something. Especially when you're trying to act in good faith. And then the judge, depending if you actually spoke to the police officers or not, under duress, give you some leeway or a higher punishment. It essentially means, regardless of your right to stay silent, regardless of your right to speak to the lawyer, you are under duress to speak to them. And, personally I've had this issue myself. I was almost convicted of a theft. It was only because my lawyer got me off in another formal way. There's 3 cameras in the building where I lived. 1 on the back door and 2 in the front. Cameras would have shown I had not left that building, therefore no charge would have occurred. Informed the police about this and they never investigated. Also never told their supervisor or the handler, I can't remember the name now, forgave that information to the court either. This is a breach of the Crime Investigation Standard Operating Procedure. I was threatened to talk to these officers because there would be consequences if I did not do so. For I was under duress. When I was presented with a photo of someone that looked like me, I was like, you know what, fair enough, it looks like me. And then I was away to say but, and then the 2 police officers turn around and say, okay, we're charging you under blah 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 blah. But because of that threat of arrest and because of that threat of consequences, my legal right to stay silent was essentially ignored because I was under duress. But we will get to that point later on as well in another video, because that's a whole video in itself. Verbal agreements are enforceable. They can be difficult to prove in court. Evidence to support a verbal agreement can include witness testimony. If someone witnessed the agreement, testimony could help support the claim. Now this one I actually think just shouldn't be a legal thing in the first place, because even Neil deGrasse Tyson had an issue with this himself. When Mr. Tyson was going to be going on to jury duty, the judge said something and asked Mr. Tyson a question. Then Mr. Tyson responded with something he wanted to respond with, or you were a witness to what I just said a second ago, and yet you misunderstood what I said and got it wrong. Even a judge can be a witness to something, it happens to him, then his knowledge base is such, and yet he can still get it wrong, and he or she can still get it incorrectly. This is why video evidence is definitely the best, or written. And even when it is written, it has to be very clear. Related documents, emails, text messages, or other communication that reference the terms of an agreement can help. Even with the verbal agreement, there's still, written parameters as such. So it's when you speak to these advisors or these call handlers as such to, agree to pay for a debt, unless they keep the recording, there's no way for them to prove you agreed to those specific terms. Not as even if they gave you those specific terms. Conduct of the party. Evidence that shows both parties acted in line with the agreement terms can support its existence. For example, you can have a verbal agreement with someone, give them a handshake, and as long as both parties agree to follow that, then you're all dandy. But that's not something you should be doing these days. Limitations and risks of verbal agreement. Dispute over terms. Without written terms, there may be disputes about what was agreed. As Scott & Co or the City Council showed me an agreement to take overpayment of funds to pay for debt 2 and debt 3. No, they have not. Statute of limitation. Claims for breach of contract must be brought within 6 years. Practicality. Verbal agreements are more likely to be used in simple transactions. For complex or high-value agreement, a written contract is typically recommended to ensure clarity and enforceability. Ensure clarity or enforceability. They have stated Aberdeen City Council and Scotland Co have not shown the agreement where I agree to give them overpayment of funds for one contract to pay for another contract I made with them to pay for debt 2 or debt 3. The fact that they have taken my money, kept it, and used it to try and pay for a debt that does not exist anymore. It's a complete violation of this contract. It is not enforceable and should not be enforceable legally. Enforcing verbal agreements in court. If there is a breach of verbal agreement, you can pursue a claim in the court, but you will need to provide sufficient evidence to convince the judge of the agreement, existence and terms. Courts will assess the overall situation, including the credibility of any witness. That's the part I dislike as well. Credibility, yes, maybe one person might be more inclined to do X thing. It does not mean they would be either in breach of a contract, or it does not mean wouldn't pay for a contract, so on and so forth. Hence why it should be written. The Aberdeen City Council and Scotland Co have not shown the verbal agreement or the written agreement to take my overpayment of funds. In summary, while verbal agreements are enforceable in the UK, written contracts are usually preferable for clarity and proof. Aberdeen City Council and Scotland Co show me the verbal agreement or the written agreement. To this day, they have not done it. There was no agreement made and there was no statement made to myself, they have the right to do this or do that, and I originally made the first contract.